Good morning. Happy Thursday. So, a lot of stupid comments on my last couple of videos from Lane Meyer supporters. The first comment that I find hilarious is, "You're making money off Lane. Your last 10 videos have been about him." Well, let's just assume, arguendo, that I am somehow on my non-monetized channel making money off of Lane. What's the problem with that? Why? How does that affect anything? What does that change? Does that make me give different legal analysis than I otherwise would have? Does it put me on one side or another? Or am I still a neutral observer who is just commenting on the facts and the law and the procedure in the case? How, like, what are you implying? You're making money off Lane. Like, and because my last 10 streams, let's say, or 10 videos were about Lane, if that's bad, then isn't Lane making money off the victim? Because he streams about her all the time. At least that's what it appears from the court documents. He likes to stream about her. Does that mean he's making money off of her? If I'm bad because I am making money off of Lane because I'm making streams about or videos about Lane, then isn't Lane also bad because he's making videos about the victim? Like, I don't think that I have not seen a single intelligent supporter among the Lane Myers crowd. Not one. And I'm not trying to be insulting. I am merely stating an observation. The lack of thought that went into that comment. Obviously, like, all of these people they're just reacting. All of Lane Meyer supporters are just reacting. They're all up in their fields. They think for some reason they have a parasocial relationship with Lane. They identify with him. They like him, whatever. They think they have some sort of a relationship with him when they don't. I mean, for the most part, I'm sure some, like Illuminate the Dark, has phone calls with him and whatnot, but 99% of his supporters or more have never talked to Lane. So, they've never developed a relationship with him. They've never broke bread with him. They've never drank a beer on his back porch with him. They're not. It's a parasocial relationship. They are not. Lane doesn't know who you are. Even if you've been commenting on his videos for years, he doesn't know who you are. I don't have a relationship with anybody in my comment section. I don't have a relationship with anybody in my Discord. We are screen names at best. Unless I've broken bread with you, I don't have a relationship with you. Unless you've broken bread with Lane Myers, you don't have a relationship with him. But I get it. I understand. He's filling some emotional need in your life, whatever, and you feel bound to him in some fashion. But just remember, you are reacting emotionally. It's your emotions here that are at play, not mine. I've never met the victim. I've never met anybody in this case. I like Lane. I mean, he's a spurg. I wouldn't want to break bread with him. There are several people who, I know most of my audience doesn't like, that I would have a steak with. Jeff Gray from Florida, not Joshua Gray, but Jeff Gray, the auditor from Florida. I like him. I would buy him a steak. James Springer, I'd buy him a steak. I've bought Nasty Nate a steak. I've had dinner or lunch or meals, I guess, with Nate at least twice that I remember. There's normally alcohol involved, so maybe I don't remember all of them. But not Lane. Lane is somewhat entertaining. But I wouldn't, Chili Castro, I don't know. I mean, depending on what drugs Chili Castro was on, he would probably be an entertaining dinner companion, or he'd be completely insufferable. The mini stages of Chili Castro, right? But you don't have, I mean, Google it, parasocial relationship. Like it's a one-sided thing. You have all these feelings for him. He doesn't know who you are. So, another gentleman, very upset, wanted me to call him. Didn't give his phone number. Somehow he thinks that I'm a government employee. I'm a first-year family law attorney out of California. I mean, look at the way I'm dressed. Do I look like a government employee with my beard? I am not a government employee. I have never been a government employee. I am a first-year family law attorney out of California. I can't get your phone number, dude. I don't have your phone number. A lot of people are concerned because in order to get access to my Discord channel, you have to have a verified phone number through Discord. In other words, you have to give Discord a phone number that they can verify somehow. I think Lane was trying to use a Google phone number. He wasn't able to get Discord to verify him for reasons that I don't really understand. I mean, I'm not Discord, but I don't have anybody's phone number, even if you've joined my Discord channel. Discord has it. I'm not Discord. I'm a first-year family law attorney. If I own Discord, I'd probably be able to retire, but I'm a first-year family law attorney heading into a deposition that I'm not going to get paid for today. So I can't call you, dude. But he keeps going back to, gotta go back to where it starts. It starts with the victim's husband committing prosecutorial misconduct by charging Lane for booing at a city council meeting. Now, first, I'm not a huge fan of all the rules at city council meetings. A lot of city councils have rules where you can't boo, you can't clap. I saw that a lady was arrested for clapping at a city hall or town council meeting where the city council or town council, whoever, county council, where they had decided not to allow a data center to be placed within their jurisdiction. And she clapped. And she was arrested for it. And I know a lot of people think, I read a lot of the comments on social media under it, and a lot of people think that, it's because of what she clapped for. But those rules are in place. The idea behind those rules being in place is that you can't disrupt the council meetings by booing or clapping. Booing for anything, clapping for anything, you're supposed to maintain a decorum. And they're always questionable. I'm not a huge fan of those rules. I understand them. I understand why they're in place. Doesn't mean I like them. But you have to remember that those council meetings are generally speaking for a short duration of time, and there's a lot of people, generally speaking, who may want to speak, and so they have to give, set periods of time to those people because the meeting is only going to be so long. It's a set meeting. And if that meeting is interrupted by long bouts of clapping or long bouts of booing, then that eats into everybody's time to actually address the council. And also you're taking up, that's not your allotted speech time when you're clapping or booing or what have you. So I don't know exactly what the rule was in place that this city prosecutor decided to file charges under against Lane. But those rules are pretty common. And just because a particular I don't know exactly why the city court, whatever, threw it out, dismissed it. I don't know exactly why, but I would assume that the language in that particular, in the rules for that particular city council or what have you, might have been a little bit too harsh, might have been a little bit too restrictive on First Amendment. That's my guess. But that doesn't mean the prosecutor committed prosecutorial misconduct. That's your legal analysis. Great, you're entitled to it. That doesn't mean it's correct. You'd know it's correct if a judge found, or if the bar, the Arizona State Bar, found that he committed prosecutorial misconduct. Prosecutors are allowed to bring charges if they believe there's probable cause for the charge. That's the bar on a prosecutor. That's what he has to have in order to bring charges. That doesn't mean that he has to be right, that he has to get a conviction. It means he just has to believe there's probable cause, and he has to convince a court there's probable cause. And once he's done that, there's no misconduct. There can't be misconduct because he had probable cause. Now, if he had fabricated evidence, sure, that would be prosecutorial misconduct. But there's no allegations of that, at least not that I'm aware of. Lane Myers booed. Charges were brought. Where's the misconduct? I know you don't like it. I know you don't like the fact that there were charges brought. That in and of itself doesn't make it misconduct. Disagreeing with charges doesn't mean the prosecutor committed misconduct. There was some rule that he was trying to enforce. The judge disagreed with either the rule or his interpretation of the rule, and the case was dismissed. Where's the prosecutorial misconduct? And that's a rhetorical question. I don't really care. That case is done, resolved, over, fini, kaput. The judge has made the ruling. Congratulations. If you want to say that Lane Myers didn't violate the law, great. You've got a judge that backs you up. I'm going to agree with you. But just because Lane didn't violate a law doesn't mean the prosecutor did. And again, I want to point out that Lane Myers supporters are using like two-headed thinking. They're looking at everything that the prosecutor did in that city hall town council case in the worst possible light. No charges were brought against that prosecutor. No disciplinary action was taken against that prosecutor. So what you should assume from that, what you should draw from it, if you're rational, which again, Lane Myers supporters aren't, is that all of the legal experts, all the professionals, the state bar, the judge, other prosecutors, don't think that he committed prosecutorial misconduct. Your mind should be blown. So you see crimes where no one else does, and somehow magically you don't see crimes, Lane Myers specifically, the ones he pled guilty to, where everybody else does, including Lane Myers. Weird, two-headed thinking. Like you guys have cognitive dissonance out the ass. But even all that prosecutorial misconduct bullcrap, like that's all irrelevant. Let's just assume, arguendo, that the prosecutor did commit misconduct. Then what? All of a sudden Lane Myers is now allowed to harass the prosecutor's wife? To stalk the prosecutor's wife? Things he pled guilty to, so they're not in contention. There is no doubt about them. You may not believe it, but Lane Myers pled guilty to it. He believed it. It doesn't justify it. Sometimes actions that would otherwise be criminal are by just the dint of when they happen, are suddenly legal. For example, you can't normally punch someone in the face. But if someone is assaulting you, if they're battering you, you can use self-defense. You can punch them back, right? Someone pulls a gun on you, you can pull a gun on them. Self-defense, right? Stalking and harassing, though, is not self-defense. There is no affirmative defense to harassing and stalking that, oh, well, her husband committed prosecutorial misconduct. This is a non sequitur. These don't follow. There is no justification, legal or moral, for Lane Myers to stalk and harass, things he pled guilty to, the wife of someone he has a beef with. No justification. And if you think there is one, well, you're in the minority of a minority of a minority. You are the 0.00001% of the population. You are 1 in a million or less. It's stupid. The beginning of all of this nonsense is when Lane Myers started harassing and or stalking the victim. That's the beginning of this. It's not the prosecutorial misconduct. Yeah, the prosecutorial misconduct probably triggered in Lane's mind some weird need for revenge on the prosecutor's wife. But no crime was committed until Lane Myers decided to stalk and harass the prosecutor's wife. That's when it started. That's when this started. And it's not justified by the fact that he thinks he was done dirty by the prosecutor, by anything the prosecutor did. No justification to stalk and harass the prosecutor's wife. None. Period. That is uncontested, uncontroverted. There is no legal professional that will tell you anything otherwise. Maybe Vernon Peltz will, but he's disbarred. Got back another falsus in what do you say? Falsus in unum, falsus in omnibus. It's falsus in uno, falsus in omnibus, but whatever. You know, you can't expect much from these geniuses. And once again, while that is a maxim, it is not mandatory. It is not automatically applied. That's first of all. A jury instruction could, in theory, be given to the jury, provided the judge and the attorneys on both sides all agree to it. Well, I guess technically, as long as the judge wants it, it goes in. But usually one of the attorneys has to advance it and the other attorney has to not have a good objection to it. And then the instruction is given to the jury, but then the jury gets to do with that what they want, right? So that's the first thing. Second thing is, that's for witnesses. That's for testimony. That's for evidence coming in. Lawyers, the DA and the defense attorney aren't witnesses. They are not giving evidence. They're not giving testimony. Anything they say is argument, not evidence. If the only evidence, and I'm using that word loosely in air quotes, that comes in about elements of a crime, any of them, because the prosecutor has to prove every single element of the crime in order for the person to be convicted of it, in theory. If the only thing that comes in that covers one of the elements is argument from counsel, from the prosecutor, there's no evidence. And the judge will probably sustain a motion to dismiss based on the failure to prove every element, to provide evidence of every element of the crime. Because what the lawyer says is not evidence, it's argument. So the jury will never rule on that. Your falsus in uno, falsus in omnibus maxim will never become a jury instruction as to the attorney, because the attorney isn't giving evidence. And finally, material facts are all that is important. Immaterial facts are not. A material fact is something that would lead the juror to find in favor of one side or the other. That is a material fact. An immaterial fact is something that has no relevance, no bearing on, in this case, the crime. Lane's prior relationship to the victim, alleged prior relationship or whatever, saying that he previously dated the victim would only be a material fact. It would only be relevant if there were domestic violence charges being brought. You may notice that there were no domestic violence charges being brought. His relationship with the victim, his prior relationship with the victim, is not material. It is not relevant to any of the charges that were brought. It is an irrelevant detail. Whether it's true or not, it's irrelevant. I would be shocked if anybody got the grand jury transcript. I'd be shocked if there was a grand jury transcript. But I'd also be shocked if anybody got it. If someone does have the grand jury transcript where this allegation was allegedly made, I would love to see it. I would love to put this baby to bed. Because all these Lane Meyer supporters just keep droning on about this falsus in uno, falsus in omnibus, not realizing that it is not an automatic thing that gets applied, not realizing it doesn't apply to a non-witness, and not realizing that it's not a material fact. So I'd love to put it to bed. So if you have it, please get it to me. I feel bad for Lane Meyer supporters because they are stupid and they don't realize they're stupid. That's the whole Dunning-Kruger thing, I guess. It's been debunked. Well, I see it all the time. So, I mean, maybe the theory isn't as sound, but I mean, look at the world and you can see it all over the place. The less someone seems to know about a topic, the more they think they do. A la Lane Myers. A la Lane Meyer supporters. So, again, I feel bad for them because they don't know how dumb they are. They don't seem to understand that they're getting legal advice, legal analysis, legal commentary from a guy who doesn't even have an HVAC license, apparently. Doesn't have any college, apparently. Doesn't have any paralegal training, law school, nothing. He's got a Westlaw subscription. Congratulations. That doesn't mean he can understand what he's reading. Apparently, he can't understand what he's reading because he's citing cases that don't apply for propositions that aren't real propositions. There's a difference between being able to read something and being able to understand it. As an attorney, you get trained on how to read the law and interpret it, understand it. He doesn't have that training, which is why he keeps going in there and his attorney is telling him, the DA is just stomping all over him and the judge is siding with the DA. There's a reason why that happens. It's because Lane doesn't know anything. And you guys are looking at him like he's some sort of legal genius. This guy yesterday was like, oh, Lane's going to be a rich man by the end of this. Lane's probably going to be in prison by the end of this. If I had to bet on it, I'd bet Lane was going to be in prison. Not because I'm psychic, omniscient, anything like that, but because of my legal training, because I can read the law and understand the law and apply the facts to the law. Even in Arizona, because Arizona uses the same kind of legal system that California does. And I'm not licensed to practice in Arizona, but I can still read and interpret their laws and read their cases and research their cases and get a much better idea much quicker than what Lane Myers can. So, I mean, if you want to listen to him for legal advice, congratulations. But just remember, garbage in, garbage out. Thanks for watching. Have a great day.